So, Renato, the trial in Manhattan is coming to a close. How did the witnesses do in this case?
It's complicated. I'm Renato Mariotti. I'm a former federal prosecutor, a practicing lawyer, and a legal analyst.
And I'm Asha Rangappa. I teach national security law at Yale University. I'm a former FBI special agent, and I'm a legal contributor for ABC News.
And we're here to help you understand topics that can't be boiled down into a soundbite or a tweet. So, Asha, I don't know if there's a witness more complicated than Michael Cohen.
Yes, I think the last time we talked, we were talking about him as well. And the cross-examination had just begun at that point, and then a lot happened after that.
Yeah, it was. I still stand by my commentary that I think it was the cross-examination was all over the place. I really think having a sharp, focused cross would have been better. But I think it's fair to say that the defense did land some blows on Michael Cohen. What was your take?
Yes, well, the one blow that people seem to focus on a lot, I did not think it was that compelling, was this idea that Cohen, I guess, made a 90-plus second phone call, which he had claimed was to Trump, and it was about Stormy Daniels, but then I guess conceded on cross that he had also spoken, or that he had spoken with Trump's bodyguard, Keith Schiller, about a different matter. And I guess the defense counsel was like, so you lied. And he's like, no, maybe I talked to Keith Schiller, but I also talked to Trump. And it became this like big thing. And I didn't feel that he had necessarily been like, it was a big gotcha moment, but it was treated like a big gotcha moment, both by the defense counsel and from what I saw covered in the news. And I was like, maybe I missed something.
Yeah, I mean, it depends on, and it's hard to tell without actually being in the courtroom, how the whole testimony goes. So sometimes you can have these witnesses that tell this like very beautifully crafted story. Okay, they're the prosecution flipper, and like they've got this fantastic story that just sounds it all lines up. And the way it all lines up is that, the defendant's guilty. And then like there's something that shows how much the prosecution had prepared the person, or that they're not sure about basic things. So like, the only way that would really be a problem is if it kind of revealed that like he's saying everything was with Trump and it's not, or like he seems like he's got laser sharp memory of all these conversations, but then when you actually ask him about it, he gets confused. So that would be the only way in which it would be an issue. I agree with you that, as somebody, obviously I was not in the courtroom every day. I was not going to, go to New York and stand in line for hours to do that. I don't know exactly how that would have landed. But my reaction is that there was an overreaction on the part of the press there. I mean, he's already somebody who said a lot about Trump, and there was so much to his testimony, and the cross went on for days. Like, I just don't know how much that particular piece is going to land with the jury.
Yeah, it just didn't seem to me that what they were introducing was mutually exclusive with what Cohen had said. At most, as you said, it might be that, okay, his memory isn't as crystal clear, at least definitely about this particular conversation. And so maybe you should cast doubt on everything about the conversation. But the kind of Perry Mason moment, like, you lied. I was like, well, that's a little extreme, I think, and probably overly dramatic. And I think on redirect, Cohen got rehabilitated to some degree because I think they had a photograph of Trump with Keith Schiller at the time of the phone call. So, it made sense that both could have happened. And I understand that they actually demonstrated for the jury how long the 96 seconds or whatever is, which could be a very long time to talk about a number of things.
Yeah, I will say I don't view that as a Perry Mason moment. When I was a kid, my parents made me watch Perry Mason. It was okay. It was always very dramatic. I had a case where I had gotten the flipper to admit that my client and him did not conspire to commit crimes, which was a problem for the government in a conspiracy case. that you could say is a Perry Mason moment. But even there, it kind of was in the midst of a lot of other things. It didn't feel like that at the time. I doubt that this statement about one conversation amongst many really stood out. Another thing that I saw tossed around, Asha, as like, oh my God, this big moment was Cohen admitting that he inflated the numbers to get like an extra, I don't know, $45K out of the Trump organization, which is embezzlement, theft. I mean, there's no way around that. That also to me felt like very overstated. I mean, I was told, I didn't watch, I've been very busy with work, so I haven't been watching all these television shows, but I'm told that everyone said this is going to result in Trump's acquittal. I mean, to me, looking at it from a distance, everyone knows that Michael Cohen is a convicted liar, a convicted fraudster who makes his living in part by criticizing Donald Trump and attacking him. So why this would be the straw that broke the camel's back in terms of believing his account, I don't know.
Yeah, and to the extent that he inflated, I mean, I assume this is inflating something, the legal services for something was it for reimbursement for the Stormy Daniels payment?
Right. I think he added $45K in there. And so Blanche made a big point out of this. And of course, they're treating it as legal services, not as like him just throwing this extra payment.
Yeah, I'm just, again, confused because also he like part of that. I mean, there was a component of the invoices that he was supposed to, what did he call it? What was it? What was the phrase they used to bump it up to account for the taxes?
Right.
So it's like he's talking exactly like, it's like, okay, you just made the point of the prosecution, which is this was all shady stuff. This was all shady shenanigan stuff. And yes, and maybe Michael Cohen like skimmed even more off the top. But in other words, again, it doesn't, to me, it doesn't it doesn't disprove like any major element of the case.
Well, for example, if Stormy Daniels was stealing from Donald Trump, it would have been more of a revelation. I think for Michael Cohen, it's just baked in. I mean, to me, it's like,
it's baked in.
He's a fraudster and a liar, perjurer, but oh my God, he's also embezzling money. Like that is such some different thing. Like we already know who this guy is. He's a criminal. He's gone to prison. Like there's no way around that. So why are we acting like shocked that a criminal is committing a different crime? I don't know. I mean, that doesn't really strike me as a big revelation.
Yeah.
So all in all, I will say, Asha, I really stand by my analysis of this case from a 10,000 foot level. I think there are flaws in the prosecution's case. I think they've done a good job of working around those flaws. They've been aided at times with some rulings that are beneficial to them from the judge and frankly, some favorable law in New York. But I think the defense is all over the place. I really think the defense could have gotten a hung jury or a misdemeanor, which I think we should talk about in a minute or a little later in the podcast, if they had had a very focused approach and stipulated to a lot of things that focus on these complicated legal issues. Instead, they're just kind of all over the place and they're hitting some punches, but they're almost like some crazy person attacking whatever. Like you might hit something by mistake, but they're just sort of all over the place as far as I'm concerned.
It's almost like they're channeling Trump and maybe not their better judgment on actually how to try this case.
I think that's right. I mean, and I think that's a theme that can run through all of this. I mean, I think, if I was trying this case and you were my client, I'd be like, let's stipulate to all this underlying stuff, which Trump won't let them do. I'd be like, let's ask and argue for a misdemeanor, which he probably won't let them do, or he's unlikely to let them do. And I would not have put on a defense case unless, and to move to a slightly different topic, unless I had something really compelling. I mean, the ideal defense case here would be a bunch of Trump organization officials all coming in to say that Trump did all sorts of, or that Trump wasn't really involved when he was in the White House. And Alan Weisselberg and Michael Cohen and others did all sorts of things without his knowledge about money. But instead, we got something very different from that, right?
Yeah, we got this witness. Okay, I'm excited to talk about this guy. And I'm excited because this witness was a disaster, and we'll talk about why. And what you just said, like, but he could have just not presented a case at all. Like, why did they do that? And Fox News had basically been arguing that Trump should present this witness for several nights on their news programs, kind of claiming that it's the smoking gun. So you can, if that's true, you can imagine. I don't watch Fox News, so I'm not sure whether that's true. I know he was on Fox News. This witness was. So you can see how this plays out, right? Trump is watching Fox News. They're like, get this guy. He's going to be the smoking gun. He's going to obliterate Michael Cohen. And then Trump goes and tells his lawyer, you got to call him and you got to make him a witness. And his lawyers are like, no, dude, like, I think what we just need to do is just rest the case, make the government stand on what is done. Trump insists. And then here comes Mr. Costello.
So for those people who have not been paying as much attention and just listen to our podcast every week, who is Mr. Costello?
So Mr. Costello, Robert Costello, was a former advisor to Michael Cohen and was in communication with Cohen during the time that these hush money payments were being made. And basically, the defense put him on to further undermine Cohen's credibility. That was his purpose.
Yeah, I mean, he was, he's a New York lawyer, an older gentleman himself, around Trump's age, very prickly with the
former
judge.
Former
federal prosecutor, prickly with the judge, made various, eye rolls and statements that did not please Judge Merchan, who thought that he was contemptuous in his courtroom. And he just was a character, I think is the best way of putting it. Not somebody that you would have as a credible witness. And I think the issue for the defense is, you could throw this guy in if you were going to have 8 different witnesses or 12 different witnesses. But to have this guy as your only witness and say, this is our defense, this guy, it's a little odd, right? But it is also, I will just say, a very common result in criminal trials. I mean, everyone imagines when they get indicted for something that all these people are going to be rushing to their defense. Oh, I have all these friends, I have all these family, I have all these people, all these business associates. Everyone's going to want to support me. And then when the rubber meets the road, no one actually wants to take the stand to say anything, is usually how this works. And so, this is what you're left with. You're left with, in this case, some random guy from Fox News who comes in and says some random stuff. And the jury's sort of like, what was that all about?
Yes. And so to your point, again, he's not there to actually contradict any of the fundamental claims.
He wasn't there. He doesn't know.
Elements. Yeah. Exactly. He doesn't know. He's just there to attack Cohen. And I want to go back to this point about him being contemptuous in the court. So have you ever been on a jury?
Yeah,
Renato?
I have.
Yeah. I mean, I feel like, I don't know what his, end game was in that, especially being a former prosecutor and a lawyer and understanding courtroom dynamics. I didn't understand where he thought he was going to get with that, except maybe pleasing Trump by demonstrating his contempt for the entire proceedings. But in terms of the relationship with the jury, I feel like the psychological dynamic in a trial is that a jury looks up to the judge. The judge is looking out for the jury. And so there's kind of this, I think, a bond of trust between the jury and the judge. And somebody who is being really rude and contemptuous to the judge, I think, would turn off the jury.
Yeah, I think
the jury would be like, what are you doing? Like, you're being an ass.
Right. I think that's right. And just more generally, I would just say prickly old, character kind of guy, difficult, person throwing bombs is not the sort of person that's generally going to get a jury to like them anyway. As a practical matter, very few people are going to find that appealing. And really, to me, the issue is having this as your defense witness. So I want to talk at a higher level here in terms of trial strategy about when you put witnesses on at a trial. So what I would say is ideally in the defense, you would have some counter theory of the defense where you're going to put on your own story. And then the prosecution's like, oh my God, they're dealing with a surprise. You don't have to disclose much of that in advance. And you have this totally alternative theory. What happened here, is obviously they didn't have that opportunity. They didn't have anyone who's willing to do that. And so, your choices are essentially put on, like, sometimes there's you have a character witness for the defendant. Oh, he's a great guy. He's very truthful or whatever. Sometimes you put on like some witness, expert witness who can say, yes, here's my expert opinion about business records or campaign law. But when you're doing that, like, the jury is not dumb and they recognize that, okay, this witness doesn't really move the needle. And so in that circumstance, you're usually better off doing nothing. Like, you either have to have some good defense witnesses or nothing. Because if you have nothing, you can go to the jury and say, look, we didn't have to put on a defense. We could have. We decided not to because the prosecution case was awful. And let's focus on the prosecution's case and how bad it is.
So you're reminding me of one of my favorite movies, My Cousin Vinny, where they bring up the Marissa Tomei character, who turns out to be an expert in cars, to testify that the tire tracks that were left were not made by the car that was driven by the defendants, and then that, like, basically ends the entire case. That did not happen in the Manhattan trial. And so what do you think I mean, this has to have been, again, a Trump-directed move.
Yes.
I mean, his lawyers seem like they're decent. Like, they seem to generally know what they're doing. I mean, I would think that they would know that.
Yeah, look, Don Blanche is a good lawyer. He was at a very fine New York law firm. I don't know what part of this is Trump versus the lawyers, okay? And so I'm going to put that out there because we're making judgments or assumptions, however you want to look at it. I think it's reasonable to presume, based on what we've seen, that the client, in this case Trump, is the one driving a lot of this. I think that's fair point. Driving, contesting every point. These are actually, I mean, they're during the cross the Cohen, like, these are actually payments for legal services. It's like, why are you fighting on that? Like, it's just it's a silly point to be fighting about. So I think a lot of that's Trump. I think attacking Stormy Daniels was Trump. I think that this witness was probably Trump, but that's just a guess. I will also say that it is not an uncommon issue or dynamic for lawyers, and I say this as somebody who spends thousands of hours a year practicing law, that it is not an uncommon dynamic for clients to drive your strategy, and for clients in their demands and their views to have an impact on what you do. Every client's different. Some are more difficult than others. Some of their ideas are great. I have certain clients who are they're like mini investigators or something. They have really great ideas. But Donald Trump does not appear like he's in that category.
So I wanted to ask you about one thing that took place during the sighing and eye rolling and, under the breath commentary that Costello was making that was irking the judge until he finally had enough. And Judge Merchan cleared the courtroom. Not just excuse the jury, but it sounds like he cleared everyone, I guess. Everyone, including the lawyers, except for the witness, and must have had a come to Jesus with Costello about courtroom decorum, I assume.
I think he cleared the jury. I don't know whether the rest of the courtroom was cleared, but in any event,
he cleared the gallery.
The gallery.
He definitely cleared the gallery, because then Dershowitz, this is what I'm asking you, was on Fox News claiming that this was like a blatant constitutional violation to a public trial.
Yeah, I mean, one issue, that's the reason I thought about that myself. There is an issue. I mean, there is that you have a right to a public trial, and that is a constitutional issue, and that's heavily litigated by news agencies for high profile trials. So it is an issue. I think the constitutional bar is fairly low there, because it's usually national security cases where this comes up, where they're like, hey, we don't want reporters in for this particular witness's testimony. And there's a lot of litigation over it. Look, I don't really, from my perspective, Judge Merchan has shown admirable restraint by not doing anything to derail the trial. I mean, just to take a step back here for a minute, Asha, I think it's an important point. Judge Merchan is about to complete, he's on the precipice of completing the first ever trial of a former president of the United States. Also, the first ever trial, for a criminal trial, of a current major party presidential candidate in the midst of an election. And there is a full jury. The jury's not been intimidated off. He hasn't been losing jurors. And the trial, in my view, has gone in a fairly normal lane. In other words, there are rulings by the judge that you can criticize or debate, but they're all within like a reasonable lane of what you could expect a judge to do. And, they're not crazy. There's just nothing super out of the ordinary going on here. And that's an achievement for the judge and for the American criminal justice system. I think, he cleared the courtroom. He said what he said to the witness to try to get him under control. There's a few times where his bark has been different than his bite, so to speak. I think that's just fine. Like let's just get through this trial and get to a verdict.
Yeah. Well, apparently whatever he told him, I think worked because it sounded like Costello kind of got it together after that.
Yeah. He's a lawyer and he has a greater responsibility than a typical witness. He's an officer of the court.
Yeah.
So let's talk a little bit about jury instructions. I will just say, Asha, that in my experience, jury instructions are often outcome determinative in cases. That the outcome of a trial can often be based on the specific jury words in a jury instruction, because the jury hears all this evidence and then they go back there and they look, they're either reading if they're given a copy or they're listening to those jury instructions, taking notes. And sometimes the specific words there can be very important to them. So I think that they can have a very substantial impact on the outcome. And I think one really interesting thing, and we don't know as of the day that we record this, where this is Wednesday, the 22nd of May, it's not known publicly, and I don't think it's possible to know whether or not Trump's team has requested that a lesser included offense charge be included to instruct the jury that they could find that Trump committed a misdemeanor but not a felony. But it appears, based on the submissions we can see, which really focus on the disputes between the prosecution and the defense, it looks like there is nothing on that. And if that's the case, that is quite a gamble by the defense. And it could mean that Trump is once again, to go to your theory, influencing this because he doesn't want to give an inch, right?
That's interesting. So I'm curious, because I would have thought that's also a gamble for the prosecution. Because if you're only giving instructions for the greater charge, aren't you leaving open the possibility that, say, the two lawyers on the jury are like, start getting wonky and are like, I don't know that they really showed the intent to prove or conceal. And then there's nowhere left for the jury to go. And so it's a quit. I mean, can it go both ways?
Great question. The answer is no.
Oh.
And it's because the statute of limitations has been blown on the misdemeanors. And but the statute has not been blown on the felonies because of COVID and the fact that Trump was outside of the state. That's told.
I see. So the prosecution did not have the option at all as a matter of actually convicting him on misdemeanors. But you're saying the defense could have argued that maybe for fairness reasons that should be a lesser included charge that the jury should have the option to take.
Right. The defense can make the request for a lesser included offense instruction to be included. If the judge believes that's appropriate based on the facts of the case, the judge can give that instruction. I think the judge would have done so here, I think, clearly. And to me, that's the obvious choice. So in my hypothetical where I'm representing you, we would do that 100 times out of 100. Because if at the end of the day, my client is only convicted on a misdemeanor,
that's a win.
And the defense side, that's complete and utter victory. Okay. I'm like dancing on the courtroom steps. Like, you came after my client with 30 something felonies and you're getting a misdemeanor conviction. Like, that's great.
But wait, now I'm confused because the 30 something counts. I thought, were they all felony? They were all felony counts, or I thought that was misdemeanor and then the misdemeanor bump up, or no?
They're all bumped up to felonies, but they can't charge just the straight misdemeanor. So the jury has got a choice of felony or nothing. Now, that can be a viable defense strategy. If you're very confident in where you're at, you could say, I don't want to give a compromise. I mean, there have been times, Asha, I've been in front of the jury on the defense side, and I've made super clear to the jury that if you check guilty as to one count, even one count, it destroys my client's life. And so, because I think I'm going to win, and I want them to make sure that they don't compromise back there and be like, okay, well, we got one guy who thinks he's guilty and the rest of us think he's not guilty. So we'll find not guilty on 18 counts and count guilty on one, that sort of thing. But similarly here, I mean, you could say okay, we're going to win. So let's give him the stark choice between felony or nothing. But I think it's very risky here. I mean, Trump is in Manhattan. There's going to be a lot of jurors who are not going to want to quit him. There's a lot of evidence that the prosecutors have. There's a lot of, you always would want to have that misdemeanor option if you're on the defense side, in my opinion.
So you noted that apparently has not been presented to the judge.
It doesn't appear. We won't know for sure until Judge Merchan moves his lips and gives the jury instructions, because there's a possibility that the defense put it in there, the prosecution didn't object or note it in any way, and it's just is going to the jury. But it doesn't look like it.
Can the judge sua sponte do it?
Not without the defense asking, no.
Okay.
That's not the charge. So the defense would have to make the request. They have the ability to make the request, which is very interesting. Mm-hmm. There have been, I will say, and just to kind of get to a related issue here, there have been a lot of debates about the jury instructions, which I will just note is very important for an appeal. All these issues about a trial, what Cohen says or Daniel says or whatever, that stuff doesn't really matter as much on an appeal, because that's the standard on appeal for reviewing that is very deferential to the trial judge, in this case, Judge Merchan. But the jury instructions are purely legal issues. And so if the judge gets that wrong, that can be a real problem on appeal. And there are some disagreements about that. And one thing I will note is that Judge Merchan, there is not complete specificity, I would just put it this way, regarding what we've talked in the past, Asha, about the New York election law conspiracy that is the predicate offense that is bumping everything up to a felony. And there is not a lot of clarity from the prosecution about exactly what what are the unlawful means for the election conspiracy there. And the judge, I believe, has held, and this is, I think, correct under New York law, but it's going to be appealed for sure, that it's not, he's saying there doesn't need to be unanimity regarding what that was. So in other words, you could have 5 jurors who say, well, it's they were doing it to conceal one particular election law offense. The other 7 jurors are like, no, it's this other election law offense. And we're not requiring the jury to have unanimity and unanimously say, this is the offense that this was intended to conceal.
But I thought that was just the law in New York, because I recall several prosecutors from Manhattan who've prosecuted these kinds of cases in other contexts saying that from the outset. Because at the time, the question was, remember the indictment was so weird and boilerplate. And we were like, well, what's the underlying crime? And we talked about the bill of particulars. This is a year ago. We have it in an episode.
I criticized it.
Yeah, you criticized it and talked about, it doesn't specify. But at the time, I remember lawyers who were commenting saying, actually, he doesn't have to specify. And I remember this very specifically because I remember being surprised at the time that the jury doesn't even have to agree on what the underlying predicate crime is. So are you saying that this would be appealable? And so, in other words, if this is kind of the law and how it's been applied in bread and butter cases, do you think it's a vulnerability on appeal used in this context?
It's an issue. I would say, look, the reason that I took the position that I did, and I was very publicly critical of Alvin Bragg's team on this, is I do think it's fundamentally unfair and particularly bad, and it's really bad for the public in a case charging the former president of the United States not to specify exactly what he did. Okay, I just think that was wrong. that has been corrected to a good extent, not completely, but largely corrected by the prosecution, to their credit. I give them credit for that. But this, you're right, that under existing New York law, you don't need to specify this. But I will say that most of the time, it is in cases when this comes up, it is cases where it's obvious as to what the other crime is. Like, in other words, you've committed crime X, and the underlying, it's obvious that it's intended to conceal a kidnapping or a murder or whatever it ends up being. And here, it's not clear what that crime is. It's very unclear. And, there's a saying, bad facts make bad law or whatever. I mean, I do think that there's an element to which this is such an unusual circumstance and such a high profile case. And it does seem, unfair in the United States of America that the defendant doesn't know exactly what the crime is and the jury doesn't have to agree on exactly what the crime is. It wouldn't shock me if there's an appellate court in New York who has a different view of this.
Well, let's clarify a little bit, though, because it's not just, Bragg's team has not gone in there and been like, we think they concealed these business records to commit another crime. And, you can make up whatever crime you want. They did specify that, or at least I know that Judge Merchan was giving instructions to, or at least Katie Fang reported, the election crime under New York law, section 17152, conspiracy to promote or prevent an election. Any two or more persons who conspire to promote or prevent the election of any person to a public office by unlawful means, and which conspiracy is acted upon by one or more of the parties, shall be guilty of a misdemeanor. So they did specify a law. I think the issue is that law has language that it's a conspiracy to promote an election by unlawful means. What are the unlawful means? You and I had a conversation before that we can't be circular. The unlawful means can't be the falsification itself. It has to be something else. And is that what you're saying is the unspecified part?
That's exactly right.
Yeah. Okay.
A conspiracy always has like an object anyway. It's not like you conspire in and of itself. There's some conspiracy to do something unlawful. A conspiracy is an unlawful agreement, right? It's agreement to break the law.
Yeah.
So here it's like, what's the unlawful means? And there are various theories that have been thrown out by the prosecution. And it's possible that some jurors are convinced by one and others by another. That's not usually what you want or what you expect in a criminal case. The way it's supposed to work usually is that everyone agrees and there's unanimity because it's proof beyond a reasonable doubt. And that's part of the due process protection a defendant has. So I agree that that's been the law in New York. I do think the cases that have come up have been very different from this case. I do think that there is some appellate risk there for the prosecution. Candidly, I think the prosecution is happy to live with that. If they get a conviction and then there's some appellate issue and they have to go back, they'll do that. Okay. But they're arguing aggressively under New York law as it is currently stands. But I do think that is definitely a risk. And that's why you're going to see some discussion about that among, between the attorneys and so forth, and some complaining about that, I would say from the defense side, understandably, in the days to come. So, Asha, before we go, there has been a crime committed in the Mariotti household.
Oh, God.
The evidence of that crime was that when my beautiful dog Henry came home, his trademark poofy ears have disappeared. The groomer got very enthusiastic, and he literally does not look like the same dog. So we will put up a photo on the YouTube version so people could see. But he got
clipper happy?
Yeah. It's going to take months for these to grow back.
Oh, no.
I know. It's devastating because it is the ears kind of make him. It's like, I don't know how to explain it. That's like his thing. Yeah, it's his trademark look.
Does he know? Is he aware? Does he feel kind of sad?
My wife believes that he does.
Yeah.
I don't think so. I don't think he really knows, but my wife believes that he does. And so it was absolutely devastating. We're hoping that it grows back soon. I am kind of curious. Have you ever had like a haircut that went like totally bad where like you gave him an instruction and it went like very sideways?
Not in a long time because I don't do like dramatic haircuts. But yeah, it's upsetting. And I've had to have my cat shaved. I don't know if you know, but cats
what?
Yeah.
Oh, that's very concerning.
Yeah. So, Chuckley, my last cat, as he got older, he was unable to kind of bathe himself like properly.
Oh,
so
yeah.
he would get like these matted fur. And then it was like this whole ordeal because I would take him to the vet, but then they would have to like sedate him to shave him because otherwise like he would like attack everybody. When he was a kitten, I took him once to like Petco to the groomer because they said they do cats, and they basically like at the end when I picked him up, they were like, he could never come back here again because he had just like, I guess, attacked everyone in sight. But yeah, it's sad because then they come back and they don't look like the same pet.
It's huge.
Like all skinny, like he came back all skinny and like, I don't know, just sad looking. And the reason I asked whether you think that Henry knows is that I always felt that Chuckley knew that he looked like a sad, skinny rat cat.
My wife believes that's the case. I will say Henry had to have shave on part side because he's got a liver disease. So there was a time where he had to get like an MRI and they had to shave part of him and, sedate him and everything. And, that was weird, right? You kind of had part of your dog shaved or whatever. So I totally get that. And with cats, I think when they're shaved, don't they keep the head the way it is? So
yeah,
it's
like a lion. It's like a lion cut.
Yeah, it's super weird, right? You got like all this fur on their head and then you've got like nothing behind.
Yeah. I have to shave the fur around Pancake's butt. I'm sorry, I have to just confess that. Like, it's like, I guess, super fluffy down there. And when I took him to the vet, they were like, we need to give him a sanitary shave. And, they charged like, I don't know, $50. And I was like, okay, do I have to come back like every 2 months and like pay $50? They're like, well, you can do it at home and you can get, and he's a really good cat. He's not like Chuckley. In fact, he got a certificate of bravery for being so good when they gave him the sanitary shave. It's he's got it on his little kitty condo right now. It's hanging there. But now I have to do this every 2 months.
Wow. That's crazy. And the things we do for pets.
That's what I'm saying.
MSW Media.